Am I audible to all?
Yes, sir.
Okay, ma'am. Your voice is extremely. Just a second. Check. Yes, thank you very much for the introduction, and special thanks to some of the people who have kept their cameras on. Uh, now, uh, I'm not sure whether I'm properly audible, sir. Sirno sir or Bagare sir. Okay, thank you very much. So the topic is very general for today's discussion. I assume that all of us have done one or multiple cases relating to the real estate insolvencies. And most of us know what is it, what are the challenges faced by uh, various stakeholders in the real estate insolvency. As a practitioner and as an advocate in the Supreme Court and NCLT, I have the chance to represent all the stakeholders in these kinds of insolvencies, being it the resolution professionals, home buyers, builders, bankers, etc. So it will be great if we can share the various experiences which we had in these insolvencies. And further, my request to all of you is to uh, ask as many questions or give as many suggestions as possible, because uh, having a constant monologue by one person for 2 hours will be very boring. So as long as there is a discussion, it will be easier to keep this session moving forward. Uh, so I'll start with sharing the PowerPoint presentation, but that is just for the beginning and uh, to begin the discussions. So,
जी बाय कर रहा है मैनकाइंड ऑलमोस्ट 2545 के आसपास स्पॉट में ये स्टॉक अभी चल रहा है। बहुत ही स्ट्रांग स्ट्रक्चर है अनिल जी। देखिए कल एक स्टॉक ने एक टर्नअराउंड की कोशिश की थी, बट क्लोजिंग पर 2500 से ऊपर ये स्टॉक नहीं निकल पाया। आज फिर से एक स्ट्रांग टर्नअराउंड पर देखने को मिला है। कल के हाईस के ऊपर
so we are getting a great stock advice by someone, and state insolvency. So, if may I ask, how many of you have been a resolution professional in a real estate insolvency? Anybody so far?
Sir, myself, B.S. Bhadoria. For me, it is my first case of the real estate project.
Okay.
Yeah. So I may have a lot of questions.
Okay. So how many home buyers? Like first, let me have a few questions from you, and that will set the context. How many home buyers are there? Allottees are there. Home buyer is a wrong term, perhaps.
Sir, there are approximately allotment cases are for around 1400.
Okay.
Yeah, but claim-wise, I have received almost 600 or so. But fortunately or unfortunately, what has happened with me, that in my case, the CIRP was admitted for the company as a whole in the first instance. So I am, sir, there is some noise from, I think somebody is
Yes, somebody.
using the TV, I think, television.
Yes. Sir, I request you, one of the whoever is saying his business secrets out, please keep it to yourself.
I think to the host we can request to ask that person, because from screen we
Ma'am, could you
cannot.
mute the person who is who has switched on his television? Actually, कोई नहीं सर, ये चलता रहेगा, आप आस्क करिए, क्वेश्चन करिए.
Yes, sir. So in my case, sir, I have connections and keep on receiving requests from more than 600 people who have already filed a claim with me. So there are queries from home buyers which are not under CIRP, but CIRP, but with different IP also. So that is the status as far as claims are concerned, sir.
Okay.
But for me, it is quite challenging as well as quite satisfying also, because the moment you get into something new, your brain start working actually. So you have to use your brain and skill to handle that assignment, which is new in itself. So, but there are certain questions which definitely, being a professional, I wanted to have perspective of other professionals also as to how they are handling such cases. But so far, I don't have, I have no problems as far as my activities are concerned. But still, I go with certain apprehensions in my mind. So I would avail this opportunity to.
You ask, sir, right now. You start firing the questions and we'll.
Yes, sir.
we'll
My
go on
main
for it.
question
So,
is, sir, actually, my concern is because, you know, a lot of information is shared with the COC, which is comparatively sensitive and quite confidential also. And I have to share the same with the AR, because AR is the person representing the home buyers. Now, home buyer AR always comes back to me, sir, मैं क्या करूं, मुझे, you have to tell me what I should do. So I have to keep on requesting him to advising him also whether to share this information or not, because sharing is necessary with the COC members. And as far as AR is concerned, his limitation and his response is also legally correct, because he has to act on behalf of home buyers. So unless he shares information or documents which he receives from RP with the home buyers, he will not be able to seek the comments from them. And he has more challenges in to some extent, because home buyers is a typical case of claimants where, especially in my case, it's a affordable housing. So everybody is so dissatisfied for the non-delivery and non-refund for almost 10 years. So they keep on asking, sir, हमारा पैसा कब मिलेगा, हमारा कैसा पैसा मिलेगा, and they are not worried about the process. They are not worried about the voting. Whatever cost we share, I have prepared the annual budget also and shared with them, and I have given them indicative amount to them, that this is something which they will have to share as part of expenses. So some groups have been formed between the home buyers. There are some people who have some political connections. As usual, they have personality of revolting with the system. So they have formed WhatsApp groups where they exchange the confidential data also with anyone, because that is unrestricted. Anybody can join. So that is also, I'm facing challenges, although it's not my responsibility, but I'm facing challenges as far as that is concerned. So these are some of the things which I wanted to seek clarification as to what extent I can ensure the confidentiality part and sharing of the information with the home buyers. And what are the practical challenges in doing so? Because, they are least concerned about the process. They never ask any questions relating to CIRP, relating to the corporate debtors, except कि जी ये cost हम क्यों दें? Why should we share the information of expenses? हमें तो पैसे दिलवा दो आप. Beyond that, they are not able to proceed. So at least I have gone to certain extent. We have issued the Form G also. And from the corporate debtor also, now the cooperation has stopped because there were some ED raids and all those things. So that is the problem, sir. So this is generally the gist of what I am facing actually.
Okay, sir. Thank you very much, sir,
Yeah,
for the
thank
first question. And I'm really
Thank you, sir.
happy to share the experiences so far.
Yes, sir.
First of all, as from a legal perspective, I would like to address what is confidentiality and what is not confidential, and how far a thing is confidential and where the limits of the IP is decided. So, as far as the confidentiality is concerned, if the basic human tenet is if two-person knows an information, it's no longer confidential, because the person who has given that information in trust does not have the control over the action of the another. The only way in IBC a resolution professional can safeguard himself when sharing the confidential information with any of the parties, that if the information is by confidential in nature as given in the IBC, like IM or etc., then only that particular information has to be given to that particular shareholder with a confidentiality undertaking. But as far as real estate project goes, it is extremely difficult to maintain 100% confidentiality because people have found the way to find out every information. The reason is very clear. Am I audible now? Yeah, so there was a disconnection. There was some electricity issue. Okay, so Badurya ji, if you can switch on your camera, it will be really helpful to give answer to your questions if it is possible for you. So the idea of confidentiality is very difficult to preserve, and as such, being an RP, your interest lies in complying with the provisions rather than making 100% sure that the information remains confidential. Because in all the real estate projects, what has happened is the land is one of the most valuable things. If it is partially constructed, half constructed, or if anywhere there is some value in it, people try to find all the information for possible takeover by multiple means. There are rival groups within the allottees. There are ex-promoters, there are bankers, and there are freelancers. And they have multiple ways to know the information which they want to know by any means. For an example, information memorandum is confidential. As per the IBC, the resolution professional is supposed to publish the G form. Anybody can apply for under the G form for getting that information memorandum, etc., eligibility criteria, etc. And there are on the same day when the G form is published, the people scrap the data from the IBBI and it is sent to the multiple stakeholders who might be interested in such a project in and around the area. There are dedicated firms who pitch themselves as like the resolution makers. They put that data available to their client that if you are interested in that project, we can help you to build the rest of the ladder or the pipeline by which you can acquire that project. And with these firms, multiple people on board to get the IM. And once they know the eligibility criteria, they design every RA in such a manner that they meet the criteria and they get the copy of the IM. So even the documents which are by very nature confidential, the people have the means and ways to get it. Another very common way, the minutes of the meeting. Minutes of the meetings are to be circulated. It has to go to the every stakeholders. And as you have experienced so far that the WhatsApp is a wonderful thing. So multiple people are part of those WhatsApp group only for the purpose of getting the information. Everybody knows the process now with the ChatGPT and Perplexity and so many other AI platforms. They want to get the answer. They will definitely get the answer. But with the help of that WhatsApp group, they post every preposition. They test every preposition, whether what the statement has been made by the RP is correct or not, whether he is behaving in a particular manner or not. So, first answer, whether it is possible to guarantee that 100% of the information remains confidential, the answer is no. The IBC is structured in two ways. One, the information which is completely public, like which has to be notified in the newspaper or on the website as per the IBBI norms. Those has to be published. Those are the public documents. The information which has to be shared in the confidential, the people who are interested in that particular information will have the ways to find out that information. So it's not possible to keep every information confidential, and it should not be kept in confidential at all. Two, whether it is likely to cause harm, it is very difficult. Sometimes it creates a market for the project, creates more value. Sometimes it is destructive. But either way, compliance has to be there. But as far as the information which is required to be passed on to the COC member should be given to them. It's not at all confidential, and it cannot remain confidential in under any of the provisions. Hope that answers somehow your questions. It's not 100% guarantee, but that's how the law has been structured so far.
Yes, sir, I understand, sir. Thank you very much. But still, because the approach of RP is always questioned as far as the confidentiality is concerned. For example, there are certain data of unsold inventory and all those things which we have not disclosed in the detailed process note. It will be part of the information memorandum. Now, there are consultants who are RPs only. They are running RPE firm. They are calling me, you share this information. I requested them, you become part of the process. You know what he remarked, that person who is RP, कि sir RPs के साथ यही problem है. They just focus on process and they don't want to ensure that the project is there are efforts to find out some RA and all those things. Because I responded that I appreciate that marketing is also one of the critical role of an RP. But it has to be ensured that process is followed. So people expect that they should not be part of the process after the EOI, but still they want the information.
Yeah, that will be there. Suppose if you do not give, they will go to the RERA authorities and get all those informations. Even if it is not there, they will wait and they will become a resolution applicant and then share that information.
That's
So
true.
your approach so far is absolutely correct. If the particular information is 100% confidential, it is not to be shared. It will be shared at the time of the IPO.
True. Thank you, sir. Thank you very much.
Thank you, sir. So thanks for the first question. So we have to see this entire thing in the perspective of how the law developed so far. So IBC came as a revolutionary legislation with fundamental changes in earlier existing laws. It did few fundamental things. One, it took over the control from the existing management and given it to the creditors. This was the one fundamental change. Two, it took away the discretion of the adjudicating authority to a great extent compared to what we have seen in the High Court, where the insolvency proceedings used to lie, where solvency is to be decided. So that has been done away with debt and default. Then there are strict timelines to be imposed in IBC. The people criticizes the IBC a lot, 3 years, 4 years, no resolution. But if we compare with the last historical legislation, the earlier BIFR or the Companies Act used to take 5 years, 10 years to resolve a particular company. Vis-a-vis that, the current regime, the timeline is pretty short. But as a legislation, it has come as one size fit for all when it was first enacted. So there was no sectoral bifurcation with like the real estate or anything else, or telecom or energy, etc. And it was made applicable to all kinds of the sectors at the same time with uniform timeline and everything. The broad effect of that was that this particular, because it was not tailor-made, it was not very successful in one of some of the gravest problems. And one of them is the real estate. In real estate, the challenges are completely different than the other sectors. For example, it's not that any sector does not has a challenge. So I'll just give 3 examples. One, telecom sector. In telecom sector, one of the most important thing as an asset is a license and nothing else. So, and license is not owned by the company, it's the government. It's only a license to use it, the spectrum. So they had a different kind of challenges. A judgment came from the Supreme Court and now they are changing the law, etc. So power sector. Huge capacity, change in regulation, the plants became ideal, huge capital investment, different kinds of creditors, etc. They also went to the Supreme Court. The Supreme Court said, no, we are not changing anything as per the law. But when it came to the real estate, the things changed entirely. Because the quantity of the cases in this sector was highest. The number of people who were affected in the real estate were the highest, in the sense that there are in the NCR, there were lakhs of flats or inventory which was lying. The people were not getting homes. And this particular IBC framework was not suitable. So the first of the things, if we delve into the evolution of the law, in 2016-17 till 18, there were only 2 classes of the creditors, financial and operational, and that's it. And there was a great category there was a great debate. Debate is still going on, but there was a great debate at that point of time that in those 2 definitions where the allottees do fall. So people started using the word home buyers, but as per the RERA, the actual term is allottees. So whether it's a home buyer or a commercial shop buyer, it's irrelevant. As long as he is an allottee, he is a stakeholder in the process. So they were not financial creditors and they were not operational creditors, because the definition case, if you give the money for the time value, then you are a financial creditor. And the OC, if you have supplied the goods, materials, services, only then you are the operational creditors. They were not finding place in any of those. So the people started questioning the way they have been categorized. And one of the first few successes came from the NCLAT, where few of the agreements which were between the allottees and the builders, the NCLAT says by virtue of the nature that there are assured return given, they have become financial creditors. So how those agreements were structured? So when the pre-launch offer was going on, the people purchased the houses or the shops to say that we are giving you the X amount of money, say 10 lakhs, 20 lakhs, 30 lakhs. Till you give the possession, at least 1%, 2%, or 5% return on that investment is coming back to the person who has sought an allotment. So that the court went into the structure of the transaction and concluded that the nature of the transaction is such that it has the commercial effect of the borrowing, and therefore these people are the financial creditors. Now, somebody has found a way. Thereafter, it became a race in every litigation for every person, wherever there is a slightest the amount of return is given, to categorize his case as a financial creditor. Looking at the gravity of the problem, the government has come out with some kind of solution. The government has realized that these are the class of people which requires protection. Right now, they are not getting the seat in the COC and they are not getting any say in the process. They should be deemed to be financial creditors. So the first amendment in the favor of the allottees, which somewhere came around 2018, was to make the allottees as a financial creditor. It had two aspects to it. One, it's a deeming fiction. Two, even otherwise they were kind of creditors if we go by the strict interpretation of the Transfer of Property Act. And thirdly, in a way, most of the developers were financing their project using the money of the allottees. So I'll bifurcate all the three preposition in 1, 2, 3. 1, it's a deeming fiction. Deeming fiction is, it is an admitted case that they are not financial creditor, but we will deem it, though they are not, but we will treat them as a financial creditor, was the case put forward by the amendment. 1. Otherwise, they were a financial creditor. There is a Transfer of Property Act, very few people ever applied. There is a section 55, which says that if you have purchased the property and you have given a consideration towards the part performance of that contract, and that property is being transferred or something is done, you are a secured creditor with vis-a-vis that particular portion of the money which you have advanced in respect of that transaction. That was not applied, but still they were. And thirdly, now Mr. Baduria is dealing with a project, so they must come across that developers had limited resources to raise capital for these projects. So there were very few financial institutions which are funding these real estate projects. So developer found a way to come out of that capital shortage situation by marketing the project in the to the public even before it actually went live. So the typical business motion work, the developer will execute an agreement with the landowner. They will buy outrightly or they give a land share or something, and they said that we are going to launch a project which will be this much, wonderful pictures. Then they went to the banks and they said that this is how we are trying to develop the project. Would you finance our people who buy a home in this? So there was some kind of credibility attached to that advertisement by putting it with the logo of the banks. So huge advertisement with the bottom that this project is approved by so and so or financed by so and so banks and etc. So there was large scale of funds which came into the project, which was actually in the financing, but they were given the facade of a home loan, because the people thought that maybe in 2 or 3 years the value of the property will become double or triple, 100, 200, 300, 3x, 4x, 5x. The home loan interest is 8%, 7%, 8% maximum. And commercial borrowing is costing 18% and above. So it makes sense to encourage people to take loan on 7% and invest it in the project. So that's how the entire transaction was structured. And this money, which sometimes where the returns were given, is called subrogation and etc., where various FIRs is going on and the things are pending in the Supreme Court as of today. The money was pooled in the real estate projects. So this is how the corpus was built. Initial corpus to run the project was built. Even before the project went live, even on papers, the units were sold off. Everything was in the air. And that was the norm of that point of time, because there was no RERA, nothing. The project was not even registered, not required to be registered. No escrow account, you can allot anything to anyone. And suppose you say that flat number so and so, then that is only in the imagination, because there is no government documents which identify that particular piece of parcel of land or a piece or in the air as the flat on the document, and which can be verified or which cannot be allotted to a second person. So there was a chronic problem of double allotment, triple allotment, etc. Things went by. Industry saw major changes. GST, demonetization, RERA, and all these things have ripple effects across the real estate industries. And many of the changes were brought which were consumer centric. RERA was a consumer centric. And IBC was made consumer centric by the various changes. So that's how the First Amendment came into picture. The problem with the First Amendment was the same which with many other earlier provision was that the threshold was very low. So IBC as a chain mechanism can be triggered off by any allottee or even by an operational creditor having 1 lakh, 2 lakhs. So this very amendment was actually challenged to say that this is violative, etc., etc. Government even realized this. If a company of say 500, 600 crores or 1,000 crores can be taken into the IBC, which is kind of a insolvency or restructuring mechanism by a person who has 1 lakh or even a one flat in 1,000 home buyer scenario, it's unfortunate. And in order to avoid that situation, the Second Amendment was brought into force. The Second Amendment was, by very nature, was very simple. Increase the threshold. So only the people, if the project is in a serious danger, then it can be done. So they put a threshold of 100 or 10%. Suppose if there are only 50 flats, it can't be 100 allottees altogether. So the 10% figure is there. And there is 100 figure if there are like 5,000 flats. It's not possible. So 100 and 10%, that change was brought into the system to make sure that entire insolvency mechanism is not misused by the people just for the purpose of the recovery or arm twisting the builders. So that was the second major amendment to the IBC. Any questions so far? No? Thank you very much, sir. So I assume that all of you are getting. If there are any questions or you want to share some experience, please share it. So that's how the second amendment for the first time came. The nature of litigation changed. The nature of litigation changed. Now, the focus shifted into resolving the insolvencies. Large number of companies between the first and second amendment, or after second amendment, real estate companies went into the insolvency. One of the key challenges which all these real estate insolvency is the number of stakeholders, allottees, as well as the others, and of the data. So when the project fails, the promoter tries to save himself. Section 19 application will not work. First, because it takes few days to get an order against the ex-promoters or their people who were associated with them to get an order that you cooperate. And even if that order is in the favor of the resolution professional, there is no certain mechanism by which it can be implemented, because most of these orders pertain to sharing of the information, and information can be shared only when it is available. And if it is not in the interest of the person who has the information to share that information, then it's all the more difficult. So all the 19 applications became a problem. No cooperation, people seized of the vehicles, offices, sometimes the project. But despite seizing, there is hardly any tangible result which were coming out of it. The second challenge in all these proceedings with the number of stakeholders was who owns the land and who owns the flat. So there were multiple kinds of arrangement which you can see in all kinds of projects. One, the first kind of arrangement is that the land belongs to the landowner. He has just given the permission to develop that particular land to the developer without transferring any right whatsoever in the nature. These kinds of arrangement is more popular in, say, Gurgaon. There is another kind of arrangement, which is, say, Noida, where the land is owned by the Noida Development Authority and the developer only has the license. Then there is a third way where the land is in the name of one company who is either the licensee or who is a purchaser, but the development is done by the another company. But the marketing and the selling is done by a third company. So there is a bifurcation at all the three stages of the stakeholders. One of the comparatively rare situation is the housing societies owns the land, the builder develops it, and the marketing is done by the third company. So the major challenge is that there are so much varieties within the structure frame. So there is no unified structure where you can target only one type of company and get a complete resolution. Now, what is the challenge? So if an insolvency is only against the developer or a builder, the landowner says, what is my fault? I never ever transferred the ownership. I have only given the right to develop the land and I haven't taken any consideration whatsoever. One, that argument is still being debated. Two, The Noida Development Authority or the statutory body says that we have the statutory dues. We are not going to fall into the waterfall mechanism. Ours is the hard real estate. That's the only asset in the world which is real is the land. That's why it is called real estate. And the real estate belongs to us. So they have to pay us no matter whatever is the IBC mechanism. We are the secured creditor in the law. Thirdly, the company which is different, who owns the land or have the license and has no connection with the developer and etc. So all these situations, there are different kind of solutions which were found out over the period of time. So in the first scenario, where the land is not owned by the development company and but still owned by the landowner, there are litigations still going on. What should be their treatment? And there are two line of arguments which are being debated. There is not yet final authoritative judgment from the apex court laying down a concrete guideline as to how these cases should work, where landowner has not taken any compensation or amount from the builder. He has only given a portion of the land to develop. So his portion or his FAR, which is retained by the landowner, increases in value, or he can sell off that FAR or completed flats at his own will. So that's one part of it. Two, the Noida Development Authority, they started saying that we are the secured creditor. Ultimately, it was held against them. And recent 2026 amendment says that these are the statutory dues, will not have the, they cannot disturb the priority under Section 53. Thirdly, the situation where there are bifurcation of the companies. So in one of the cases, the Supreme Court went behind the corporate way to understand the structure of these three companies. And the Supreme Court has found that there are fair amount of control exercised by one company or another. And the companies were merely formed for financial structuring and etc. They pierce the corporate well and saw the thing, and they can say that the complete resolution can be given of such companies. So that's one part where the stakeholders are different, and solution has been found by the court to some extent as to how the stakeholders are dealt with. Now, coming to the one of the second stakeholder, key stakeholder in all those proceedings, and how their interest developed over the period of time, is the allottees. Before we proceed further, anybody has any question? I assume that all the questions are answered, but be that as it may, the second stakeholders or majority stakeholders are the allottees. So the situation of the allottees are very typical of a film producer or kind of thing, who is investing the money to produce a film. But if the film becomes flop, he is neither creditor nor a consumer. So the home buyers whose money was pumped to make these projects viable, and most of the projects in Delhi and NCR, the home buyers, even in the bigger insolvencies, even take an example for JP, the banker who took the JP to the insolvencies, their debt was around, I think, 600 crores, 500 and odd crores. And the allottees shares were more than 1,000 crores. So they, as a class, are the biggest stakeholders in the entire process. But prior to amendment, they were not even getting a seat in the committee of creditors, who were taking all the key decisions vis-a-vis the running of the company during the insolvency and after that as well. So that was the situation. These people were not considered as a financial creditor till the amendment. Once they were considered financial creditors, the major challenge was that who was informed and who was not. This is one part of the problem. So many people, the projects were sold in Delhi NCR across India and abroad. So whoever has dealt with the real estate insolvency, they will come across the people who have purchased a flat in Noida and they are living in Guwahati, Kanyakumari, even Andaman Nicobars, Dubai, America. They want one flat there. These people have resources. They wanted to live in a good city at some point of time or just have an asset at some point of time. They were sold all across. Once the IBC says that these people should be notified by way of even publication in 2 newspapers, one vernacular, one English, having national circulations. But who in the world, even in Delhi, reads all the newspaper notification that that particular company has gone into insolvency? Rarely. So the people were not able to file the claim within the time period given. There were repeated applications being filed after the time period is over for filing the claim before the NCLT for condonation of delay. Sometime it was being condoned or not. So first, all the applications, there are flooding of the applications. The government became wiser. The first modification came at 90 days period. So everybody who got to know late, sooner, later, can file their claim within the 90 days. Only a part of the problem was solved. Still, many of the people don't know it. They kept on filing. Ultimately, through NCLAT and the Supreme Court, came with an authoritative pronouncement. Till the resolution plan has come, all the claims which has come before the RP should be admitted. And to reduce the number of applications, there was a proposal that these applications to be filed even by the RP before the NCLT. So that collation of the claim and number of the stakeholders, that was one problem for the authorities. 2. The second problem is that a lot of these transactions in earlier days were executed in cash. So the challenge before the RP is how to verify those transactions. The allottees have the receipt which says that this much amount has been paid, but there is no bank account which can tell you that whether that amount has come or not. So verification of the claim is another challenge. Ultimately, the RP is not an adjudicator and can only collate the claims. That was a notion which prevailed for many years. Now the thing is, okay, they can reject and accept it. That's one part of it. Then thirdly, how much interest? So before the norm for the interest was finalized, everybody was charging the interest at the whims and fancies. Sometimes it was as per the agreements, but agreement has 2 types of clauses, one for the promoter, one for the allottee. When the default was on the part of the promoter, there was hardly any amount which was to be given under the contract. But when the default on the part of the allottee, it has to be on a higher side. Then the RERA provisions came and it became uniform that if the interest rate is not stipulated or something like that, then the 8% is the norm for charging of the interest for claims. So further clarity was given. So IBC being economic law has been changing on each and every aspect so frequently. And every time one problem is coming, another problem is coming. The courts are improving the process. So is the Insolvency and Bankruptcy Board of India, and so is the government. There is no such act where so many amendments have taken place over the period of time, which are so drastic in nature. The IBC is still being amended, and by its very nature, it seems that in the future as well, they will keep on amending it. So the next challenge was the number of stakeholders and the allottees and how their claims, the delay of the claims were crystallized and everything. Now the next stage which came is regarding keeping the company as a going concern, as well as allotment of the flats and etc. So before proceeding to that, do we have any questions so far? Yes, Sanjay ji, any questions?
So how does... Yeah, hi sir, my name about the... Hello, am I audible?
The voice is a bit
Am I
breaking.
audible?
Try again. Could you try again, sir?
Am I audible now, sir?
Yes, better.
Sir, so you mentioned about the RPs. I'm sorry, I'm having to put my video off for now because my connection is weak. But you mentioned about the RPs having to, look at cash claims also. So let's say if the purchaser has paid some cash amount towards the receipts or towards booking the flat, then how does the RP really of claims? Like, is there disputes which keep happening on the front? How does this get addressed?
So there are 2-3 varieties in these claims. The first variety is the claims where those cash deposits are reflected in the books of accounts of the companies. So there is a verification possible and the claims have to be accepted. 1. 2, there are second category of cases where the cash receipts have been proved before the consumer forum and there is a decree in the favor of the allottees from either consumer dispute forum or the RERA authorities. So that has to be accepted. Third type of the cases where the original receipts which are verifiable in nature are still with the allottees, where the signatures could be matched, the receipt number could be matched, and the amount could be verified by some means from the records of the company, that has to be accepted. The only cases where the amount should not be accepted as a claim, where their original receipts are missing, there is no books of account, there is no verifiable trail of issuance of those particular receipts at all, and there is no bank account receipt or order of the court. So the last type is liable to be rejected. And that's how, based upon documents in any of these categories, the RP has to accept or reject the claim. Ronak ji, does that answer your question?
Yeah, I got it.
Okay, thank you. So, thank you for the questions. Any other question? Anybody else?
Sir, I have some questions regarding the sharing of data by the promoter, sir.
Right, sir.
Sir,
Please ask.
actually, when the corporate debtor is having multiple projects, so definitely if one project goes into CIRP, and one by one, almost 2-3 projects also go into the CIRP, then there are multiple RPs appointed. Now, in my case, what has happened that they are saying that they have not created project-wise accounting in the matter. And since they have not created project-wise accounts, so they are not sharing with me. So in such a situation, how we can handle this situation, sir?
That problem is
because we have no right to seek access to the entire accounting process. Correct? Because that is related to other projects. So we cannot insist on them that you share the entire accounting data with us. And unless they share the accounting data, we cannot hand over to the transaction auditor also.
okay. Brijesh ji, that's a great question. Thanks.
Yeah.
I have a difference of opinion that some of the something which you have stated, like since the data is dual purposes, it is not it can't be accessed by you. So ideally, I'll give you the first practical answer which should do. Rather yourself deciding that whether that particular data is another project I should ask or not, you should file an application before the NCLT. After writing an email to the other RPs or the promoters or the whoever is holding that data to supply that data. That's the practical suggestion. One. Now, why
19.2 is the option which I have availed, sir. It is in process.
Okay, great.
But sir, 92, we all know how which is effective. In one of my earlier assignment, the resolution plan is approved, but 19.2 is not disposed of even today after 1 year of resolution plan approval.
See, that's a systematic challenge. But there are two types of people. Probably it's very difficult to get 19.2 complied by an ex-promoter or their employees. But once a 19.2 notice goes to an RP or somebody who is holding another project under their custody because of any prevailing law, he cannot have or he cannot dare to refuse providing that data. So,
no, sir, all RPs will say that we are not concerned with your project. Although I know that even other RPs don't have the data because same problem they must be facing. Same problem because in project-wise insolvency, they will not, the promoter will not hand over the entire accounting data to them.
see, let's break down the bigger problem. Okay, so there are like accounting is a mathematical subject, so there are less of a presumption and more of the facts.
Correct, sir.
A builder can do two things. One, he has managed, say, 5 projects, one account for all the 5 projects. All the allottees, amount received is maintained like in a general account where there is no bifurcation, all the receivable in one, all the spending in from the one. Okay. So whether you have the right to access that data or not, it will
No,
be
sir, I want to slightly rephrase the question here.
right.
In after introduction of RERA,
Hmm.
I think after 2016, there was a separate banking account to be maintained.
Escrow
But
account.
here, But here I'm talking of the accounting data, sir. Accounting is done by the company as a whole, but being the accounts person and knowing the accounting also, I know they can give the data because they can extract. But they are claiming that we are maintaining the consolidated accounting. We are not keeping the project-wide accounting. So this technical ground they are taking, which of course is not correct.
Yeah, so we are on the same page. This is on a ground which is taken as an incorrect premises. As long as a slightest of the data pertains to your project, which is undergoing in the insolvency, in the consolidated account, in the accounting parameters which they have maintained as a group company, you have the right to access the entire data and take whatever is relevant for your purposes. Or either they have to segregate and give it to you, or they have to give the entire thing. They cannot say that we will not give because some of it might be from other project which might be confidential to us.
Sir, what you are saying is correct. Theoretically, you are correct. I also understand this, and I also taking the same stand. But we are not able to proceed further. The fact is that they are not sharing. So how the system should take care of such things? That is the question we should deliberate along with all professionals, and what action or what kind of proposal we should give to IBBI in such situations, because these are practical issues. You know what has done ICICI, where there are multiple accounts maintained by the corporate debtor. In my case, they have 10 accounts, for example, with ICICI, and they have informed me by email that for four accounts of ICICI, they were maintaining for my project. For example, I wrote to the banker to change the authorized signatory in these 4 accounts. Correct. Now I have received reply from bankers. They have given me list of all 10 accounts, and they have confirmed that they have changed the accounting signatories in all the 10 accounts without even my request. That is a chalo banking ki problem hai. I am taking up with them, and again it is to and fro mails and all those things. But we should deliberate how we can make the process efficient, because if we understand, for example, I am coming from the corporate background because I have worked in the corporate for almost 35 years. Correct. So there are ways and means where if the CIRP regulations are defined in such a manner, because you see IBC is also monitored by the IBBI, but MCA is also active part of the ministry. Correct. Now why we are not making changes appropriately in the company's accounts also? For example, sir, IP always struggles with the list of data, list of records. And one fine day, IBC, NCLT admits the company, and the RP starts writing, sir, give me the list, give me the list. And there is no response. So why the system itself is not creating such an environment where the list of accounts, etc., is already under obligation of the corporates to maintain? And auditor should keep on reporting such compliances, so that whenever such eventuality occurs, like IBC and all those things, these things are taken care of. So that is what is, I think, I request the participant to deliberate, because practically I know they will keep on, promoters will keep on telling that we don't give, we don't give, we don't give. You know why they are not sharing the data? Because they know that the next action from RP side would be to hand over the data to the transaction auditor. He will prepare the reports for gaps, and that would result into filing of PUFE applications. That is part of their planning. और उनके दिमाग में है कि यार ये प्रोसेस जितना ड्रैग हो सके हो जाएगा, जब तक आरपी भी काम करके अपना चला जाएगा, बात का तो. Even in my earlier, I don't have experience of much of the number of insolvency cases except 3-4. In one cases I have successfully resolved, but these things have not been taken care of. My PUVE application, 66 applications are going on, and I have vacated the office as RP. Bankers, they don't keep the records. They are least bothered. It's a big challenge for us.
Okay, so whatever you said, I completely agree. I'm just trying to say the other perspective of it. So let's start one by one. Whether as per law there is an obligation to maintain the record, the answer is yes. You being an accounting person knows that Companies Act requires, RERA requires, so many things which requires that the accountings has to be there. So that their obligation is there. What happens when the person is sick and it goes to the hospital, the parameters are never normal. So when a company goes into the insolvency, the promoters will do everything to protect themselves. 1, 2, the things are not normal. So it's very logical not to get the cooperation, not to get the data in all those projects. Now coming to the second part of the query. So, PUFE applications. The PUFE applications somehow is a non-starter or a complete failure for the multiple reasons. One, there are like multiple categories. One, undervalued transactions, extortionate transactions, related party transactions, and fraudulent transactions. Let's take one by one. So first is the undervalued transaction in PUFE application. What happens? Whenever the data is supplied or not supplied, transaction auditors does his job to compare the notional price which existed at some level and say that at what price the sale was made. This is very illogical in the Indian scenario. Reason is this. We talk about 5 years prior to this date, like before COVID. How many real estate transactions were having zero cash component? Hardly any. Okay. So, assuming that the value of the flat is an X, at least 20%, 30%, sometimes 50% was paid in cash. So there are two flats adjoining to each other. One flat was sold for 100 rupees and another flat was sold for 60 rupees. Actually, both were sold for 100, but the parties decided not to show that particular portion, buyer as well as the sellers. In those kinds of transactions, the transaction auditor says that these are the undervalued transactions. One, that data is sketchy. That's an imperfect and not very reasonable proposition. That when the market norm was such at that point of time, how that particular person, allottee as well as the developer, will be saddled with the responsibility to recoup it now with actual market price. The second type of transactions, related party transactions, comparatively easier to identify. There were some related party if it is promoters, but a good number of the transactions are not so related. Employees, relatives of the employees, relatives, and so far. So these many people hold those properties in the real estate assets for any other promoters, etc., and they got it for the concessional rate for whatever capacity they were. Sometimes even the operational creditors, because the builder could not pay the amount, got in lieu of the Sharia or EINTs, etc., those allotments. So one, the value proposition is not sure. Two, there are other considerations in good number of transactions. Third, there is no benchmarking available. There is the only uniform benchmarking for any undervalued transaction which is available in India is the registries or circle rates, rather circle rates. Most of the transactions executed on the circle rates. Now, when valuer sits and makes his report, it takes the prices from the magic bricks or takes some feedback from the property dealers, so-called property dealers in the area, and take the ask price of that property as the benchmark at that particular time, sometimes even in the present, because historical data he will not have, and benchmark those very parameters and say these are undervalued transactions. So the people who have dealt with the undervalued transaction knows that the premises on which the transaction is being considered as undervalued is itself faulty. Now, it's one thing to take a company in the insolvency, and it's another thing to ask a third party or an ex-promoter to contribute the money which has already been contributed in the corpus of the company. So, looking at all those difficulties, the law has made a very pertinent provision from the very beginning. This provision is not something new. That intention or the something more than the just difference has to be proven that these transactions were like that. Without taking proper evidences, it is very difficult or impossible to prove that difference is genuine or somebody is at fault. And NCLT, by its very nature, is not a tribunal where evidences could be led and a proper determination could be met. And these highly litigated or contentious application, very difficult to decide in a forum which cannot take the evidence and doesn't have the requisite time and resources to decide those applications, and where the rewards of deciding those applications is minimal. That's one part of it. So we have discussed the undervalued transaction. Second, one of the most ignored part of these transaction audit reports is that they are thinking of a rosy picture and compare it with a sick company, which is fundamentally incorrect. Assuming a company is going into the insolvency, like it is going, say, in 2025 into insolvency, the problem started occurring, say, 5 years, 10 years down the line, or before 5 years, say 2020. Company is short of working capital. Now the promoter needs the money. He has exhausted all means. The only inventory left is the flat or the assets which the company has. Whether a distressed sale can be at the par with the market price? The answer is no. This very factor is not mentioned in the IBC, is not taken into account and projected in the reports as undervalued transactions and excess. Now let's talk of fraudulent transactions. That the money has gone from one account to another account to another account and etc. Being a businessman, if you ask a question that in a particular day, when all your vendors has to be paid in cash, how that industry can be governed, where sitting a transaction auditors in the hind side, a proof of every transaction is being asked. Real estate industry, by its very nature from the very beginning, was cash-driven industry. Why? Because it's human intensive. The people the laborers has to be paid in cash. The semi-skilled worker had to be cashed in cash. Apart from the corruption was a major issue. All these transactions were happening in cash. In order to generate the cash, every company, howsoever big and small, has done multiple transactions which are, looking at the hind side, were fraudulent. And when they have done that transaction, now somebody says that now you have done that transaction, not only you lose the company, you will the eligibility to do the business as well, and then we will further penalize you to extract the money from it. Somehow that entire premises of those transactions or the things has been looked from only one perspective. The perspective of the lawmaker was, these are the people who were responsible for running those companies. Those companies could not make the money, went into the insolvency, and therefore they should be penalized. They have to be looked from the lens as if they have committed something wrong. But assuming that thing might not 100% correct, then the law, the way it has been drafted and interpreted by NCLT, or to the Supreme Court is less fair. And because it is less fair, when the law is less fair, it is very difficult to implement. So what happens when the law is less fair? You will not get the cooperation. And that's what it is happening in each project. The promoters are saying, why to take the risk? If there is no data, no application, they are not bothered about probably of the prosecution. What they are bothered is whether as an MSME they will get a plan or they can try to get back into the company or not. Because the margins are still there. They are the business people. So the data problem is generic. If there is to be some suggestions is to be given, then for not so normal company, the process should not be based on so much of the accounting data. And these processes has to be detached from the revival of the company. These proceedings, buffet applications, extortionate transaction, nobody dared to implement, question those transaction even date. Like in real estate industry, if you see, there are loan rates which are going 33% to the builders. They were inherently draconian and impossible to achieve if entire project is to be financed from those loans. Because no house is complete in 3 years. And in fact, you want to make the profit, zero profit, then maybe you won't be able to complete any project ever with those kinds of loan rates. So the problem is systematic. An answer has to be systematic. The answer is the buffet applications has to be detected from the insolvency process. There has to be a separate tribunal to adjudicate those because those are evidentiary things. The data has to come, only then the people should be made or penalized for it. 1. 2. Whether there should be any mechanism by which the data should be available. I think even in normal companies, the data is sketchy. So n number of regulation can't make it sure that the data come at the insolvency stage. The first thing in any company which goes into a rough terrain is the day-to-day management goes into a non-compliance mode. If the company is not making money, they are not spending enough money on administration of the company, they are not paying their employees, nobody is keeping track of the data, and they have no availability of the data. These are the normal consequences. So probably IBBI or the Ministry of Companies Affairs must tune the process which is not heavily dependent upon the data for resolving the insolvencies. I don't think that any resolution applicant is interested in a company because it has the complete data. It is my opinion, it is my personal opinion, that every resolution applicant for which the ultimate scheme of the IBC is that some person will come on the White House, see the company, get impressed by the information memorandum, and pay the money and say that I will revive the company. I think the only data which is relevant is the assets in hand of the company on the date of insolvency commencement, whether it is in a bank account, whether it is in a fixed asset, whether it is in any other form. If the money has gone out by whatsoever means, that is not relevant for the person who wants to acquire the company, and it had to be detached, because the buffet application has become a means to arm twist even otherwise. There is another problem with the buffet application and data is the financial creditors who have given the loans. If you, I think, read the pioneer judgment by Justice Nariman, the Justice Nariman presumes, deals with an argument very well to say that the financial creditors are the people who have all the information which they require to run a company. This was an argument presented for the classification. The argument goes, when the loan is given, every information which is available to run the company or something else has been given to the financial creditors. They knows in and out of the company. So they are the right people to run the company as such. And that should be, they should be given the seat in the COC. Sorry. So if that argument were to be true, that information is already available with the financial creditors, at least on the date when the loan was given. What was there? All the bank accounts, all the uh, assets detail, all the personal guarantees, all the valuations, all of them are available. What is available when the date the insolvency commences? All that what is in hand. So the process should not depend upon what was missing in between, because that information is not even required otherwise for the purpose of the information memorandum or the purpose who wants to buy the company. I think that large part of the insolvency relevant has been sacrificed for that irrelevant part of it. And probably at some point of time, the policymaker will come out with some solution of it. So that's my own take on it. So that's how the PUFE application works. That's what it is. Now, as an RP, what things are hampered if that information is not available? Whether the RP can reconstruct the account, the answer is yes. Whether the bank will provide all the information, yes. Whether the allottees will provide all the information is yes. Whoever is not providing the information, either he has taken money out of the company or he is not even a creditor. If he is not creditor, he is even otherwise irrelevant. If he has taken money out of the company, the law will take its own course. So, what is hampering the process is over-dependence on the data which is unnecessarily created in the mechanism itself for certain compliances. And that's somehow has to be changed. Another important thing which happens in the real estate project is the difference in the valuation. So if you compare multiple valuations, the valuation report which was created at the time when the loan was given, the property say values multiple times of its actual value. When that same property is revalued by the valuer appointed by the RP, the value come down drastically. How that is possible and how that wonder is taking place on the real estate is unimaginable. So either the data was incorrect at that point of time, or the data is incorrect at this point of time. Secondly, as the beauty lies in the eyes of the beholder, value also lies in the person who likes the property. Many of the times, the people who are valuing the property are not aware about very nuances in and around that property. So in one of the valuation reports, I was looking at in the NCR region itself, the valuer says the factory is located, he valued the entire property as an industrial property, applied a marker, on the top of it, he took the value of the plant and equipment and topped it up with the land value. So there was a huge difference in the valuation. But the question arises is whether you will be able to sell that property at that price. Impossible to sell. Reason? The valuer did not have the opportunity to look into the fact that there is no industrial zone existing where the property has been valued as an industrial land. So it's an illegal factory where how could there be a premium on illegality on the top of an illegality? So there are litigations in many of the properties. One valuer says zero value, title is disputed. Another says if we take the litigation out of it, it might be valued at X. Both are correct. But this information is useless. Reason being, neither that litigation be taken out of that property because it will attest, even if it is finally decided that who owns that property, whether the corporate debtor owns or not, or whether license survives or not. So that will remain. So it can neither be zero, neither it can be the full value. So the valuation exercise, the PUFE application, these are couple of assumptions. Perhaps for practical reasons, they will have to be segregated from the insolvency resolution profession. Because the person who is coming to take the property must come for the reason what is left in the company on the date when the company goes into the insolvencies. If some simple rule can be made by the IBBI, or companies are fair, then this problem might be resolved. But if they keep on making the laws that this much data should be there, the valuer has not done a proper job, or this must be done by any other person, it will be inherently unfair and very difficult to implement. That's my take on it. Brijesh, I hope that gives my perspective on the question raised by you.
Yes, sir. Yes, sir.
Yeah, so that's my perspective. Like, no law. If you make something, take an example. Like, there is one thing in the law making process, somehow for populist reasons, all over the world, the law has been made which is inherently unfair just to appease the people. Take an example, many woman-centric laws. So once you make the law which is unfair, where there's no fairness when the matter is being decided, then it will be misused and very difficult to implement. So this is what happens, and they are counterproductive. In the IBC as well, overemphasis on 19 application, overemphasis on the data which doesn't exist, overemphasis in the PUFE application. No court has ever decided any application for extortionate transactions, to my knowledge. In fact, that is not. There is hardly
and we are 10 years into the insolvency proceedings.
Why? Because the people are looking at the lenses. Okay. So initially, all the reforms which came into the IBC initially was marketed as a great thing for the business owner. If somehow the business has gone wrong, you can come out clean and you can start a new business. This is how it was marketed.
Yeah, you see, principally, I appreciate the intent of the government. Unfortunately, the intent is not being implemented for one reason or the other. Government intent, I must appreciate, is clear. They focused on revival of the business. Okay. Now, when I am so frustrated in making this statement, when we sit in front of bankers who are COC, you have to deal with a person who is not beyond AGM level of person. The person is participating in the COC and at the same time receiving 100 columns from his superiors and just switching on and off when the COC proceedings are going on. And he always off the line, they always insist, what is the recovery? Nowhere in my CRP assignment, the COC members have ever asked any questions as to what will happen. We should take care of the workers' interest for revival. We should take care interest of the vendors also for revival. Nowhere, never. So what I want to say in a short, without taking much time of yours and the participant, that the spirit is good. but actually the misutilization of the law is rampant. And there is a need to take uh, certain measures which are effective in handling. You see, this presently when we are discussing the buffet transaction and all those things, it is not going to make any difference. It is not useful at all, except putting the RP under pressure to follow the processes. That's it. In my case, I have been persuading the puff transaction by a lot of investment in investigations. And the IBVI, although they are our regulator, but with due respect to them, they issued notice to me on the basis of application complaint filed by the director, who filed the complaint in NCLT also, in IBVI also on same matter. I personally drafted that response and gave approximately 1400 pages of reply. And at the end of the day, I requested that these actions I have been taking against the promoter who has taken away the assets of the company, and you are questioning me just because he has complained just for GST registration renewal lapse. What about the assets which he has taken? And I am persuading tooth and nail against him. And that is one of the tools he is using to put me under pressure of these complaints. Filing before the NCLT also, and here, and you also are just forwarding the same complaint as it is a show cause notice to me. Although it was not a show cause notice, it was just complaint forwarded to me. So I think, every RP would have different kind of temperament. Some would concede to the pressure, some would fail in following the process. These things will make life of RPs and process very difficult.
Right.
I hope at this platform, if I can raise my concern, it will receive due attention.
It's good, sir. Actually, this is the right platform to raise the concern, because all of us have cleared the examination. All of us are actually doing the projects at some stage in some capacity. So law we can read, at least even if we don't know a particular aspect, but the discussion brings out the actual scenario and makes the people more wiser. So
yes, sir. Thank you.
So one of the things which came to my mind, like I represented few of the RPs in those IBBI proceedings and etc. So IBBI has a standard process, and there was no appeal provided at some point of time to the resolution professionals if some decision has been taken wrongly or rightly by the IBBI. So the writ petitions were going directly to the High Court, and IBBI was supposed to defend those proceedings. What emerged from those of few of the High Court orders is that the structured process at the end of the IBBI was completely missing for deciding those applications. Sometimes the quorum was not complete, sometimes the hearing was not given, sometimes the rejection was a stereotype email. So now there is a proper mechanism which they have devised, and there is an appeal provided to the adjudicating authority against the decision of the IBBI. So there is a proper forum and appeal, and now the things will go in a different way. Another aspect of the real estate project is, or which is the fundamental questions in all these insolvency, when the entire thing was run and many parts of these projects were run in illegal way, there is a less compliances. Take an example for the GST, PF, ESI, cash payments, how the RP can run them legally. So that is something which the people has yet to find an answer for that. And all the people are expecting 100% compliances from the RP. So another thing which is absolutely correct is which you have pointed out regarding the recovery. So the intention was to revival, but the real intention is only the recovery. And come what may, except for the allottees, hardly anybody in the company is interested in the revival. Unless the company is hugely profitable or for some other reason it has gone to the insolvency, which is rarely happened or which are very few scenarios. So we have to keep in mind what was the earlier framework. Earlier was the Securitization Act. It was complete recovery only. Earlier was the BIFIR, which is rehabilitation, which is also a complete recovery. And therefore, it is unreasonable from bankers to accept that they are interested in the revival, because at the end of the day, they have sold off their bad debts, or they are unwillingly forced into the process and became a COC members, otherwise solvent account to uh, to recovery. So the recovery is the prime motive, except for the allottees who might be to a great length interested in their home. And that's how their various provisions have come to protect their interest. So the code was amended in 2018, 2020, and 2026. Allottees made financial creditors. Financial threshold was increased from 1 lakh to 1 crore. And now somewhat the project-wise insolvency has come. As far as like the Winter Hill case, the first time the reverse insolvency which has come. So reverse insolvency where the promoter itself gives an offer or the association gives an offer that the project is viable, profitable, running, but because of the cash flow issues, it has gone into some rough patch and we want to revive the project. So this very proposal was rejected, perhaps by the NCLT. It went to NCLAT. NCLAT accepted it. The Winter Hill case went into the Supreme Court. The Supreme Court simply dismissed the case. So there is no law as such which was laid down by the apex court regarding the reverse insolvency. Thereafter, multiple judgment came which doubted the very proposition of the reverse insolvency. However, multiple applications were made, but very few succeeded on the case-by-case basis. So that was the thing. But now they have again come up with the way the COC approval, the resolution plan can be applied project-wise to. The case law has come from the NCLAT, where in order to isolate the effect of insolvency of one project into one particular project, they have started segregating that the implementation of other projects will not be affected and that particular project will be given into insolvency. But that has its own challenges that Brajeshji explained. So one, the accounting is common. With the accounting common, the another challenge is, suppose the company has taken a loan of say 100 crores. It has not taken that particular loan against the project itself. So how that effect of that 100 crore loan will be distributed? Secondly, all the projects are at the different stage of the implementation. In some, the towers are complete, the people are living. In the some, the project is yet to start. In some, the landowner is there. In some, the license belongs to another person. In some, and all the allottees are even otherwise different. So even in the project-wise insolvencies is antithesis to the group insolvency. And the challenge in both the cases are different. The challenge of the project-wise insolvency is the segregating the data, stakeholders, and preparing the right information memorandum and the people who can come and bid for the project. Because if the project is smaller, the chances of revival is higher. The lower ticket size fetch more people to interested people, because more people become eligible to bid for the project. The group insolvency, the companies are different and the data is otherwise scattered, which has to be combined and it has to be done. So the both are like contrary, the problems are diagonally opposite, or we can say different kind of challenges in both kinds of insolvencies. So now in the CIRP regulations, there are further amendments in February 2024, February 2025, where they have come out with the RERA-like regulations where project bank accounts should be managed in case the information memorandum comes. So they are trying to segregate the project-wise things. Then one of the fundamental problem which was faced by the allottees in all those real estate projects is transfer of title. So what happens if the project is ready? Otherwise, it can be transferred or registration could be done. But the company is in the insolvency. So there was conflicting opinions. Ultimately, it is now settled with the new regulations coming into effect that with the 66% of the COC approval, the RP can register the sale deed if it otherwise allowed. The second thing is, what about the flats where the sale deed could not be done, but the people are in the possession, or the people can be handed over the possession, whether that will become the part of the pool of the assets which can be given to the incumbent, which could be given to the resolution applicant, and the person who has invested his hard-earned money will lose that asset. Now the clarity has been provided to a great extent where it is assumed or it's deemed that the asset belongs to the allottee and it cannot be given to the new person and taken as a part of the insolvency process. The third thing is, since the good number of places, the land owning agencies are not part of the COC. So they have become invitees to the COC and they can take part. I'm not sure what will be their interest, why they will participate, and how that will be implemented and what will be the impact. But still, there is a provision that they get to know what is going on into the CIRP process.
Sir, I have questions. Can I take up now, or you just
Yes,
complete?
yes,
Then
please,
I'll
please go ahead. Please go ahead. I'm happy.
Sir, actually, regarding this issue is where the development rights and all and ownership is concerned. Number one, I have a question on this, and number two question is the participation by the authorities, maybe land loaning or regulatory authorities, where the land is not owned by the some industrial authority, but they regulate the development. So number one question is, sir, regarding this uh, development rights agreements. What you might have seen that most of the builders, they purchase land in their group companies name, and then they enter into collaboration agreement with the main entity, and the main entity start the project implementation. So, sir, how do we ensure the robustness of the process for the bidder, incoming bidder? For example, if in this project the land cannot be mortgaged because the land is not owned by the developer, because main entity, because it is only developing the project as far as collaboration agreement is concerned. But land owning company is a group company. And if that group company has mortgaged that asset somehow, and the RP is not able to know, although I'm investigation on those lines also, but I wanted to have your perspective also, sir. What is the safe process to be followed by RPs, and what precautions RPs should take? And number two, sir, in inviting on the land owning authorities participation. Sir, land owning authorities, to my knowledge, you are referring to where some industrial authorities like Noida Authority or MIDC or some state development authorities, they allot the land on leasehold basis, and then they are treated as the actual owner till the lease is there, maybe of 99-year lease or so. And there are other type of regulatory authorities, sir, where land is not owned by these regulatory authorities, but they charge lot of fees for proving the license for setting up of the project. It is happening in the Haryana, where town and country planning
DTCP.
department is there, DTCP we call it. So the RP has to, although we have returned to all these agencies and there is no response from them. So do we have to take extra precaution in this regard also, sir? So these are two questions from my side on this topic, sir.
Yeah, thank you. That those are most practical questions, and thanks
Thank
for
you, sir.
those.
Thank you.
So why those questions are important is because any development is related to the land, and the land is something. So your first question, if I understood correctly, there are two companies, A and B. A owns the land and it has mortgaged it to somebody else and given the development right of that company to the B. And A and B are the sister companies. Okay, so that's the broadly the situation is. So in one of the cases, you just drop me a private message and I'll give you the case name in the Supreme Court, where
Okay, sir.
similar situation has arisen. Not identical, but similar situation has arisen. This has arisen even in JP. So at least two cases I am aware where the similar situation is arisen. In the first case, a consolidated CIRP was filed against both the companies, saying that the promoters are common and therefore both the companies should be sent to the CIRP. That was
But sir,
rejected.
who will take this call?
I'm coming to that. I'm coming to that. Okay. I can just tell what has happened, and who will take this call is something which is to be decided by the courts. So in that case, this call was taken by the allottees that the both companies are interlinked and they have filed for the insolvency of both the companies, saying that the management is interlinked, and they filed an application after meeting the threshold. So the matter went to the NCLT, NCLAT rejected. Ultimately, Supreme Court went into the nature of the ownership of the companies and says that they are correlated and therefore both should go in. So that's one way of it. Being an RP, you cannot take that call. But you can always question the transaction because of which the mortgage has been created. So in JP, the transaction was questioned on the ground that the real estate company, which was the land was mortgaged by the sister company on which it is to be developed, and it was cancelled at some point of time. I think that they succeeded till the Supreme Court to say that that transaction is illegal or something like that. So now, in your case, the answer is this, that you must challenge that particular transaction and file an application before the NCLT that there cannot be two stakeholders with respect to the same thing. What happens? The analogy which could be developed as an argument.
Stakeholder means, sir, stakeholder for land.
Stakeholders of land. So as a if we go into basic fundamentals of the Transfer of Property Act, which is the fundamental governing law of all the transfer of properties across the world, and the tenants remain the same. It says that the property, a land or a property, is collection of rights. It can be lease right, it can be mortgage right, it can be sale, purchase, anything. These are multiple rights which collectively makes an asset. Now, when the IBC was being amended, And the question came, and which is still before the Supreme Court in that subrogation scheme case, where the banks are trying to attest the flat for non-payment by the allottees when the project has defaulted. The fundamental question which arising or which will being argued is how an asset which an interest has been created by an allottee, the bank can further transfer it in the auction because of the failure of the project. On the same line, an argument is to be developed when the project itself was being developed on that particular portion of the land. If the two rights have a contradictory interest, the rights of the allottees and the rights of the secured creditor who has given the mortgage or taken loan on that land, whose interest is superior in that land, you have to move an application to say that your right, the right of the corporate debtor to develop the land is superior compared to vis-a-vis the mortgage which has been created or the loan has been taken to that company. Then ultimately the court will able to answer that question, that which will prevail, and that will make the things much more clear, because two competing interests on the same property has been created. Now the law has to take its own course and decide which one is superior or which one is not. That's the fundamental question that is to be answered. So based upon the documentation and the composition of the stakeholders, like both the companies are related parties, the directors, respective controls, the court will decide which interest will prevail. If you are interested, take an example. Simple. I'll give you one more example to things clear. Suppose a property is being mortgaged twice. The first one will have the superior charge. Similarly, here also the court will decide out of those competing interests, which one will be the superior, and that will make your things more clear. So an application should be made. This is my opinion, personal opinion. One. So that's the answer to the first question. Second question was regarding DTCP. Noida Development Authority, DTCP, why their participation is important, what was the reason they have been incorporated, and why it changes the entire dimension of the resolution plan. So being it a land owning agency or being it the person who grants the licenses. So there are two regimes everywhere. Most of, like, even in Delhi, there is a Delhi Development Authority and NCD and etc. So there is one authority which owns the land, and there is one authority who gives the license to develop a particular thing on that land. Both are important. The first time the problem arose because of the landowning agencies. Why? Or even the second agency, the person who grants the permission. In the Rainbow judgment, the Supreme Court, rightly or wrongly, there are criticism on both the sides, came to a conclusion: if somebody has been made a secured creditor by the law in itself, then he should have priority in the waterfall mechanism. That was the GST authorities. Taking that analogy, all the authorities started taking the stand in all the tribunals. In our law, we are the secured creditors. Without our permission, nothing can move. And therefore, we should have the priority in waterfall mechanism. Whoever is the resolution applicant must pay overdues, whether he pays to the others or not, we are not concerned. Even if he becomes successful and he wants to develop a parcel of land, and if he doesn't pay overdues, he will not be allowed to do so. Typical example is DPCP. If a developer defaults in one project, all the projects whether they are concerned with the default or not, the DTCP doesn't allow them to give any license or whatsoever unless the entire dues are clear. In that background, in that secured creditor, in the latest amendment, the government has come out that they have to follow, irrespective of the statute, they will follow the waterfall mechanism, they will be government dues. So one problem is resolved. However, the second problem remains. The second problem remains is regarding the permissions. The permissions are very important. If resolution plans are scrutinized across of multiple real estate projects, there are multiple concessions required to make the projects viable. Why and how? Assuming that a project is a residential project, completely developed, but it can realize only up to 100x. IBC wants maximization. Now, if the master plan permits and it could be developed as an IT park, and that permission is to be granted, then that permission can only be granted by the regulating authority. If you do not take that concession at the time of the implementation of the plan, or the person subsequent to that plan is approved goes before the authority for change of that permission, it frustrates the entire object because it is flatly refused. So the idea of putting those agencies, or the advantage of putting those agencies in the resolution plan stage or the part of the COC is perhaps is that when those hundreds of concessions being sought in terms of FAR, in terms of the green belt, in terms of the composition scheme, in for IDC, EDC, FAR, and use of the land and whatnot, they are aware about those concessions, and if they want to take an objection to the plan, it can be taken at the threshold level. After approval, they should not come that we were not even aware and it can't be approved. So probably to some extent, there will be a scrutiny that whatever concession is being sought are legal or not, permissible or not, or whether there are any room for the resolution applicant to maximize that value by adopting that structuring or not. So those are welcome development. How it plays out and how many objections are raised by those authorities are yet to be tested, because these are the new provisions. These authorities are yet to come and file the objection or to the resolution plan, or the resolution applicant are yet to challenge their decision that you were part of these meetings and it was approved, you did not challenge, now you can't refuse the permission. So those litigations are yet to become and test the waters. But as such, the doctrine of estoppel will come into play, that once you have been given all the documents, you have been given right to participate in the meeting. As such, it was allowed in the law. Now you cannot come and say that we are not giving this or that for that particular reason. So those are the two perspectives on those two issues.
Jyotsna, ये ले लो. Jyotsna, इसको PRS का फोन आएगा, बता देना. क्या ना कल मीटिंग भी है. COC का बता देना. हाँ, क्या ना कल मीटिंग. और वो इंटीमेशन तो दे ही रहे हैं. Sorry.
Yes, sir, Rajesh. So does that answer or clarify some of the things?
Yes, sir. One thing is the DTCP like authorities who are not actually landowning authority, should we make them invitees, because although they are not responding, so but I think they should be given notices of COC and all those things.
So I have seen in some of the proceedings their lawyer appear in the NCLT. One, so they are coming selectively. So,
but as a RP, do we have to take some precautions and informing, although we have intimated them about the CIRP process? and requested them to file their claims or express whatever they want to say. And that's what.
I think it will be difficult that you send the information and they comply. Being a government authority, they will only honor the government authorities. So the best way to achieve that result is move an application and make them a respondent. Then only they will come and file the claim or take objections. The advantage of their presence is that if the somebody wants to come and make some concessions, give some concessions, or validity of some proposals are to be tested, it will be tested beforehand. So the chances of arising future problems because of those charges, EDC, IDC, or whatever it is, or the various permissions will be sorted out in advance. So that's the advantage I see as of today. But I'm not sure how they will behave. But I have seen them appearing in cases. So even the licenses are there, because in good number of cases, and there is an interesting thing about the DTCP license. However, it has not been adjudicated in Haryana so far. So DTC licenses are transferable assets. So these prepositions are also somehow like yet to be tested. These are transferable assets, and even after cancellation, even after like expiry, there are two terms: expiry and cancellation. So there is no
expiry is much better.
Expiry is much better.
Yes.
Expiry is much better, and there is hardly any cancellation. So they come and say that the license has expired, and sometimes the judges take, oh, license is not surviving. No, it's just payment of charges, and it gets revived. So there are many interesting dimensions to this licenses, and those are yet to be tested in the courtrooms. Now, when the projects are emerging, and secondly, it's the department is very bureaucratic ultimately, and it's one of the high stake department, and it's not easy to make those people respond. So what I've seen is some of the RPs have made an application in any form where, or stakeholders have made an application where they have been made respondent, and then they are coming and responding. Merely making them available or asking them participate, it will not work. I don't think it will work, but you can take your chances.
Thank you very much, sir.
Thank you, sir, and thanks for that question. There are only the people who have the ground knowledge do ask that question, otherwise they don't.
Thank you, sir. Thank you.
Thank you. So the revised CIRP or the anyone else has any questions so far? I have seen many knowledgeable people in between appearing and disappearing. And incidentally, I recognize some of colleagues as well. Anyway, I think they know also. Right. So this is like the judicial, reverse CIRP, judicial innovations. Major cases, everybody knows Chitra Sharma, 2017. Amrapali, Article 142 was exercised. Mansi Barar. Mansi Barar is also an interesting, which has given like multiple recommendations, and it has basically categorized the remedies available to the home buyers in two categories, RERA as well as IBC. So for individual, it says that the RERA is the first choice, and the IBC is to take the company in the insolvency if things goes wrong. There are slew of recommendations which was made in the Mansi Barar case, which has led to the lots of amendments in the things, and I think this has project-wise relation mandatory. The information memorandum has now significantly changed after those recommendations. So what broadly, I think I'll just elaborate few of them. One is allotee side filings, like just let me see my notes and see. So real estate insolvency should, as a rule, proceed in the project-specific basis. IBBI should devise a mechanism for handover of the possessions of the willing allottees. Union consider revival under fund under the IBBI, IBC. RERA authorities constitute a council to frame the real estate insolvency guidelines. Prioritization of e-filing and the case management in NCLT, registration of every new residential transaction in the local revenue authority, and contracts materiality deriving from the model RERA agreement. So many suggestions was made in this case. It was a landmark case, and it has led to 2026 amendments as well. So Umang Realtek was the leading case on the project-wise resolution. One of the latest amendment, which is extremely good for all the allottees stakeholder, is inclusion of the name of the people who have been allotted in the books of accounts. This resolves a major problem, because the person who is coming as a resolution applicant must have this information, and it is related to Mr. Baduria's earlier question that they are asking this information. So you can very well tell now there is a regulation. You become part of the process and you will get to know. So secured creditors, unsecured creditors, now it has been clarified that it will not be as per the rules and etc. And those are the amendments which are major impact. Another thing, interesting thing about these amendments, there are lots many which has happened, but all of them have not been notified. If you, I have just taken the Amendment Act, and there is selective notification of the sections, though majority of them have been notified. A good number of them are not, and some of them, part of the provisions have been notified. So that is the reason perhaps the IBBI is yet to come out with the amended Bare Act of the IBC. Another reason is that the rules are still in the process. They have invited suggestions. They have conducted few public meetings to invite the suggestions, and probably in 3-4 months they were saying, when the suggestions were invited, that the new rules will come into force. So group insolvency is also one of them which has not been notified, and many others. Rule-making powers is selectively being used. So whenever we are now discussing the amended act, one has to be really careful and again go to the notification time and again and check that whether that particular provision has been notified or not. So the Pioneer was a landmark judgment. There are few instances where the 12A has been as an interesting thing, which is very typical. I want to touch upon a few of the aspects of the 12A. Initially, there was no 12A, and inherent powers were used by the NCLA to settle the case. Lots of people taken advantage of these provisions or inherent powers and got their company resolved. And the 12A came into force along with the regulation. And the problem arose that how the things will work. So practically what was happening, that the people were going before the NCLT, NCLAT, saying that they are ready to pay the payment if it is acceptable to the operational or financial creditor. There would be a stay on the constitution of the COC, or the COC can still continue working but will not take further steps till the settlement is materialized. But things changed with the Byjune's judgment. So the Byjune's judgment came as a landmark case on the 12A, where it has been stated that the inherent power should not be used by the NCLAT while deciding the 12A application, and only the COC, after formulation of the 90% of the committee of creditors, can take that decision. So that changed the entire trend, and the NCLAT stopped giving relief to the people who were coming to the court and saying that they are ready to milling the payment. That the application started reverting back to the NCLT, where the Form FA is filed if the COC has not been constituted. And if the COC is constituted, 90% voting was compulsory, and the settlement became more difficult. Now in the new amendment, it has been formalized that the 90% is must. So the window of the 12 has been greatly reduced in the amended provisions, and it is difficult to get that 90%, and there is no reason when 100% payment has been made to the creditor why that 90% threshold is required. But be that as it may, now this is the law, and the 12 has changed, and it is very specific to the real estate project where lots of 12A plans were coming. So the revival plans have been approved in the 12A. The 12A has an interesting connotation as well. The threshold is far higher than the resolution plan itself. So if you want to get a resolution plan approved, you need 66%. But if you want the 12A to be approved, it's 90%. But a lot of clarity has come. So now the COC, the change which has taken place, that there was an in-between period where after Byju's judgment, all the people have started filing objection to the 12A application, saying that this is fraudulent or etc. And those applications were to be decided by the NCLT on the ground that the IBC is proceedings in RAM. Now it will again change, or likely to change, because once the COC approved by the 90%, the minority will not be able to question their wisdom of the commercial wisdom, and the line of argument will change in those applications. So there was Manish Kumar. There is another important case which was very typical to the real estate project, is Vishal Chelani. In this case, what has happened, that this particular gentleman got a relief from the RERA authorities in the nature of the money decree. So he got some allotment. After the allotment, the builder failed to deliver. They asked for refund. RERA allowed that application. Company went into insolvency, and the resolution applicant, the resolution professional took a stand. It's a money decree. So you are no longer the allottees, and you can't claim parity with the other allottees. The Supreme Court held that it's a hyper classification, and what is to be seen is the nature of the original transaction. And that's how he has been, the allottee has been, even if it is a money decree, was treated as allottee for the purpose of the resolution plan and insolvency process. So That's a very important 2023 judgment. Winter Hill is for the reverse insolvency. Very few cases successfully went through that path. Then monitoring committee provision has come. So now the resolution plan has to be monitored throughout their implementation process. Invitation to the competent authority. So one of the questions Mr. Baduria Sahab asked was, what is the other authorities? Even the RERA authorities, those are not landowning authorities. Those are not even permission granting authorities. They can be invited to these meetings. So IBC was treated as a last resort for the valuation, value maximization, and etc. I'm really sorry. I was having a bad fever a few days back and still carrying some of the symptoms. So broadly, these are the issues. Rainbow papers was the putting the clock back, but it has been now done away by the new law itself. So anybody has a question so far? I think let's have discussion on any open topic, and I will not bother all of you with my continuous monologue for another half an hour. Any question? Ronak ji, any question? Bagaria sir. Bagaria.
Not really, sir.
Ask anything. It's easier to ask questions. I will try to answer.
Sir, there are certain cases where these land parcels, or let's say the project, are held up in proprietorship or partnership concerns, and the personal the builders per se, while their personal insolvencies have commenced, there's it is very difficult to get these projects under the gamut of insolvency or IBC. So, is there a way out for this? While now there is a 28A which allows the PG assets and other corporate guarantor assets to be rolled into the CD insolvency, but the vice versa is not allowed. So how can we get a hold on these projects where the personal insolvencies have been initiated against the builders, but the projects per se are held in partnership or proprietorship concerns which are not falling under the gamut of NCLT?
I think there is no stricto sensu legal provision to deal with a situation where the project itself is in a proprietorship firm.
Yeah.
So there cannot be an insolvency of a proprietorship firm, and the land is owned in a company.
नहीं सर, जैसे मुंबई में सर कैसा हो रहा है कि आज के दिन पे जो जो पूरा प्रोजेक्ट है, whether it is the land or and now
अगारे जी, आप वीडियो ऑफ करके एक बार क्वेश्चन वापस रिपीट करेंगे? आवाज ब्रेक हो गई
सर। मैं बोल रहा हूँ कि ये मुंबई में ऐसे कई सारे प्रोजेक्ट्स हैं जो मान लीजिए 2008-9 में चालू हुए थे, एंड देन 2012, 13, 14, 15 दे गॉट स्टॉल्ड फॉर पॉसिबिलिटी ऑफ फंड्स एट द एंड ऑफ द बिल्डर। अब ये जो प्रोजेक्ट्स है सर, वो बिल्डर के पार्टनरशिप कंसर्न्स में या प्रोप्राइटरशिप कंसर्न्स में अलोंग विद द लीज होल्ड राइट्स ऑफ द लैंड्स, जैसे म्हाड़ा की जो लैंड होती है या जो गवर्नमेंट अथॉरिटीज की जो लैंड होती है उस पे 99 ईयर्स लीज पे बन रहे थे। So while the development rights are there, but the entire development rights along with the project is held in the partnership concerns. So how does one resolve this? Because bank loan to avail kar liya hai, but there's no way that we can invoke insolvency against these projects, which means that the recourse for the home buyers also is very limited.
Bagaria ji, I am not sure exactly what is the correct solution, but insolvency is not required if the entire asset is held by a partnership, proprietorship, or in the personal capacity. Reason being, if you get any order from the RERA authority, and Bombay has a special act as a apartmentship owner act or etc. So if you get any decree from the court, it will be directly executable against the builder itself. So he has no escape as such. Now, another challenge which is coming in your question, insolvency is not required. Insolvency is required. Insolvency by fundamental is collective resolution of an artificial person. Because company is an artificial person and you need a mechanism of collective recovery against that person. So the things can be distributed and etc. So that's what the insolvency is. But when the person is an individual or a partnership firm, the liability is joint and several, you can directly enforce the decree against the person, then you don't need an insolvency altogether. Now, the challenge which might be coming in your case is that if the builder has gone or builder is not able to develop, even if you have a decree, what to do with that decree? There is no revival mechanism. That might be the issue. But I frankly, I don't have an answer to that thing. I will try to find out an answer. But that's a peculiar situation where it is not a company, so it cannot be taken over by a second person or third person. As far as the bank loans are concerned, there is a litigation going on in the Supreme Court in such a cases like the bank can't recover or attest that thing. So you might track that litigation. It is you can search with the title subrogation schemes. So
Okay.
So there the issue pertains regarding the assured returns and the subrogation, whether the bank has the right to recover or not. So there the stay has been granted for the recovery rights on the banks on these assets, which is undergoing the CIRP. But your case might be different because there is no CIRP as such. So I don't have an answer, but that's an interesting thing. I will look into it.
Yeah. नहीं सर अभी फिलहाल तो I don't have any case, but I'm just taking cues from the discussion that I've had with some of the other lenders in the past. So the other thing is I wanted to understand that as RPs, hello, am I audible?
Yes.
Sir, as RPs, how do you deal, let's say, for example, in certain projects, there's an active interest from these PEPs, right? Politically exposed people or persons. So how do you really safeguard the interest of the home buyers or let's say the other stakeholders vis-a-vis the resolution applicants who could actually be, let's say, the PEPs, or for that matter, even the actual health and condition of the RP for getting into any kind of resolution in this case?
That's an interesting question. I'll try to answer. So there are there are many business people whose rise in the business is attributable to their political affiliation to a particular party who comes to the power. The direct advantage of that political affiliation with the party in the power is they have an easy access to various permissions, grants, etc., or access to the capital, because of which they got the project or ability to execute the project at that particular time. Now, as soon as that there is a change in the power, those politically exposed persons are targeted by the rival parties. So the direct disadvantage will happen the reverse way, that their permissions are taken away, their capital dries up, and they are unable to perform the project as such. So that is the norm in multiple real estate projects where the developers are tied up their fortune with some political party at some level in some state. So there are multiple states, all kinds of political powers are there. Now, how to deal with it? I think as an RP, the role of the RP is a process driven. You should not be interested in any particular stakeholder, and you should be fully concentrated on compliance of the law. So as long as law is being followed, there is hardly anything which can happen. So there are instances where one of the RPs went to, in Mumbai, I'm telling about like one of the RPs went into the Malund area, and the builder put a pistol in front of the table and said, "Now let's negotiate." Okay, I think it was Bayandar or Malund, I forgot. So those are the things are associated with the profession. It has to be taken with the pinch of salt. There was an abduction of the RP in, say, West Bengal. There was a police arrest of an RP. Matter went to the Supreme Court in one day. So those are the risks associated with the profession. So if you become a policeman and you are going to fight with the unlawful elements, then basically you have to protect yourself. So similarly, if you become an RP and any of the stakeholders, be the acquirer or be the person who is going into the insolvency, is politically exposed, they might try to. So in one of the earlier cases, in the first few cases, I remember there was a atta chakki. It was made a fancy name of flour mill and shown a business, and there was 6 crore rupees of loan in atta chakki. And the valuable asset was that land only. So it was in the center and it was valued more than the 6 crore. So he was threatening everybody, who work on, I'll see. So the RP was a very talented man. So he took with the security agencies and went with few vehicles and police protection and took over, and then the things came down heavily. So be prepared to fight with those things. As long as you are dealing with any stakeholders fairly, the chances of revolts are comparatively less, howsoever powerful he may be. The problem arose when you deal any stakeholders unfairly, then the fight becomes personal and it's difficult to tackle. Secondly, even if the other person becomes personal against you, as long as you are following the law, you are least thing to board. And India is a country big enough that if somebody is, say, have their approach till, say, chief minister, then somebody will be powerful enough to have the approach till better than a chief minister. So you need not bother. There are lots of people when it comes to a national level, and being in a stable democracy, mostly the law favors the one who chooses to follow it. So for example, somebody is able to manipulate at level 1, level 2, but it is very difficult for anybody to manage all the levels of the judiciary, all the management levels of the administration, and to overcome anyone. And I think there is an easier way available to one if they are not happy with the RPs to change the RP. So most of the times they will not go against the RP to that great extent. They will rather impress upon the COC member to bring someone who is favorable to them rather than fighting with somebody who is not favorable to them. So the chances of the risk is comparatively less as of today what it was maybe a few years earlier. Now you will not hear the cases where the RP has been arrested or abducted or threatened. There are very few. In earlier days when there was a lack of awareness, then things were quite different. So follow the law.
So the other thing is,
Yes.
so the other thing is, let's say during the CIRP of the project, the RP gets hold of, rather, let's say the RP has a discussion with the authorized representative of the home buyers, and they agree that they will continue the project. whether the resolution is achieved or not achieved, at least until the CIRP or the liquidation phase is over, the construction activities can continue because of whatever funds are coming in from the home buyers. Is that allowed? Can we pull in? Can we get some interim finance, or let's say some kind of arrangement with the home buyers, existing home buyers, to ensure that the construction activities are not completely stalled during the CIP process?
I think legally there is no impediment in arranging the entering finance through the COC members, unless there is some inherent illogical or illegal thing. These kinds of transactions are entirely permissible. In fact, whoever is contributing the money during the CIRP is much more secure than what they are as a financial creditor, because be it a waterfall mechanism or be it the resolution plan, they will be the first one to get paid. So if the home buyers are expressing their willingness to contribute to the corpus of the corporate debtor, to keep it as a going concern during the CIRP, then they are much more secure and it serves the purpose. So in my opinion, there is nothing illegal and it can be done.
One way they become a resolution the applicant like that.
In fact,
Together.
now, thank you, sir. In fact, now there is a provision, there could be a relaxation if they want to give a resolution plan. So the EMD and other conditions can be relaxed for the allottees if they themselves want to give a resolution plan of the company. So law is more supportive towards the allottee. It's more consumer centric now, and all the provisions favors the allottee. There is hardly any provision which is made against the allottees, except for that 100 threshold thing. Any other questions, sir? Any other questions, sir? Srinu, sir. Thanks for your intervention. Any questions? I will be happy if I can answer.
Sir, actually, my question is that once the JDA is entered by the both landowner and the developer, and the project is not completed, the both are all responsible for the home buyers. Is it correct, sir?
So there is how the development agreement is structured is very material. So there are two types of agreement which is prevalent in the market. In one type of agreement, if you study the IBC provision with the provisions of the RERA, the landowner which takes part in the development process itself become promoter of the project. So that's one part of agreement. If that is the case, then both are responsible for it. One, landowner as well as the developer. There are second type of agreement where there is a possibility of argument, where what the landowner has done, that instead of developing or taking part in the development, it has just taken portion of the future developed area. So he has not taken upon himself any responsibility for the development. In that scenario, I have my doubts that somebody can fasten a liability on a person who has no knowledge, no capital, and only has taken a portion of his own asset, will be saddled with the responsibility of a development of a project. He doesn't even have the license or know-how. And making such person responsible will be very dangerous for the overall development of the project itself. So fine nitty-gritties has to be seen within the agreement. So you examine that particular agreement in the light of the RERA provision, because RERA goes allottee, and the definition of promoter is quite different in RERA than what the normal parlance we understand. So technically, the RERA could be interpreted that all the landowners are also promoters in that. But there is hardly any judicial pronouncement in that aspect. But that's the line of argument one can develop.
Thank you, sir.
Thank you. Thank you very much. Any other question by anyone? I think all of them are fully well versed with the IBC and have understood my drawbacks, which I could not cover or complete. So all of you have been a
Yeah,
wonderful listeners.
it's a really thank you so much, sir. You are in such a position also to
Thank you very
come for
much,
the
sir.
deliverance. Then we are very thankful to you, sir, because you are not well. Even then also,
Anup ji is
Thank
opening
you.
the
Thank you very
camera.
much, sir. Thank you very much, sir.
Thank you, sir. All of you have been wonderful audience for 2.5 hours, uh, endlessly listening to an monologue, monotonous, and on a legal subject is a challenging task. So you have accomplished a
But
bigger
sir, you have
task than myself.
articulated very well, and sir, it was required, and I really appreciate the in-depth knowledge and the contours of the subject that you have covered. I think you have tried your level best. The homework, I would say, was wonderful, and that's why the delivery was most outstanding. So we have benefited from the deliberations, and definitely it's a tough task if you are actually saying something for more than 2.5 hours, and especially in these sessions where we are doing it online, the interaction is little less due to so many practical reasons, and if we do it in an offline season, the interaction is much more, and attention is also eye to eye, and that makes the deliberation more lively, more clear, and more participative. But still I feel that the wonderful knowledge that we got, we are really grateful to you, sir. Thank you so much for such a wonderful session.
Thank you, Anup ji, for that.
Thank you. Thank you very much, sir. Thank you, sir.
Thank you, everybody. And now I request the administrator ICSI to conclude the session, please.
Yes, sir. Thank you very much, sir. The session was very knowledgeable and very interactive. Sir, you are requested to share the material if you have.
Yes, I will do it. Thank you, everybody.
सर ये तो आज आप अनूप जी के क्वेश्चन से बच गए सर.
सर ये मैं सुन रहा था और बहुत अच्छा रहा सर.
Thank you, sir. Thank you.
Okay.